A couple of quick housekeeping notes before I introduce today's expert panel. The webinar will run approximately 60 minutes in total. Please take a moment now to visit the handouts area on your dashboard to download a copy of today's presentation. If you have questions during the presentation, please post them in the Q&A area on the dashboard at any time during the presentation. If you'd like your question directed to a specific panelist, you can note that when you're sending in the question. If you have any issues during the presentation today, you can email me directly at denisemkeddy@gmail.com. Just a reminder that today's webinar is being recorded and all accompanying materials are protected by copyright. Our presentation today provides general information and does not constitute legal advice. The information offered during this webinar is as of today, January 23rd, 2020. As always, we recommend that you consult with your own legal counsel to address your specific situation to ensure you have the most current information on legal matters. Let me introduce you to our expert panel today. Our legal expert today is Marla Merhab Robinson, partner and head of the transactional department at Merhab Robinson & Clarkson. Marla's firm's transactional department practices in the areas of corporate mergers and acquisitions, real estate finance, and employment law. Marla's reputation among her clients and peers is that she delivers personalized service, and she is responsive, reliable, and well-respected. Merhab Robinson & Clarkson is unique in that Marla and the other members of her firm have also worked in the corporate world, and this experience means that their firm has a unique understanding of the business challenges you face, combined with the legal concerns your company is confronted with on a daily basis. Please take note that Marla has a new email address and website if you're planning to reach out to her. Our human capital expert today is Linda Duffy, president of Ethos Human Capital Solutions. Linda and her team are known for building the magic of the human connection with their unique approach to consulting, recruiting, training, and also payroll support programs. The Ethos team works closely with your company by developing strategies for business leaders to get the right systems, people, and culture in place with your organization so that you as a business owner can focus on running your business and achieving your goals. Her clients range from high-tech businesses to manufacturing firms to nonprofit organizations, and Linda is very well versed in addressing the concerns of founder, CEO-led businesses. Also joining us today is Sarai Gonzalez-Hicks. Sarai is the payroll and HR specialist with Ethos Human Capital Solutions, and she joined the company 2 years ago and has been working closely with Ethos HCS clients who have needed payroll administration, guidance on wage and hour compliance, record keeping, benefit administration, and other payroll-related matters. Sarai has over 7 years of experience working on a variety of payroll platforms, including certified payroll and union reporting in Southern California, and she has HR experience in a variety of various industries. Sarai is in the home stretch of completing her master's in business administration this June. Linda, can you get us started this morning?
I can, Denise, and sorry about that. Forgot to actually share my screen. So appreciate you pointing that out. I would have been sitting here and nobody would have been able to see any of the slides. So we always laugh if we do at least one thing wrong, we know that we're it's going as scheduled. So let's get started with our agenda today. If you think about a lifetime of employee, there are so many documents. I used to joke with the boss and say, I want to be paid by the piece of paper, right? Maybe today paid by the email. I don't know for people in HR or business owners out there, but there's so much for a lifetime employee, right? You have all the applications and resumes, and then you have background checks and assessments and drug tests. That's all before they ever get started, right? Offer letters, I-9 forms. Then you're going to onboard them. Then you have payroll and timekeeping records. You have pay stubs, you have tenants records, performance appraisals, benefit forms, written warnings, termination forms. Like there's so much, training records, right? So what we want to try to do today is give you some guidance on how long do you need to keep what kind of records, right? We'll go through by sort of category. We're going to make some recommendations. We'll tell you what the law said, where the law is located, so if you want to do your own research. And then when all is said and done, we're going to make you like one general, guideline just to make it easier so you don't have to remember it by type of document. So the first thing we're going to talk about is posting requirements. So hopefully everybody knows that you have both federal and state posters that need to be posted. And again, if we have people on the line that are from out of state, we are going to be very California intensive today. So yes, there are federal requirements for posting, but you should definitely research to see if you have posting requirements for your state, if it's not California, and anyone may have posting requirements that are local, like San Francisco has some, uh, they have some call outs, Los Angeles, San Diego, people are going to have different minimum wages. So there's other posters that might have to be posted besides the ones that we're going to tell you about. But generally, for most employers, there are 18 required state and federal postings. In addition to that, you also have the requirement to post the wage order. If you don't know what I'm talking about there, you can go to the link on the screen, and you can also go check uh, our YouTube channel, because we did a webinar on this. I think it was last year on IWC orders. It could have been the end of the year before. So make sure that you're posting not just the federal and state postings, but also the wage order, because that is industry specific or type of work specific. Okay. If you have an employee base and English is not the primary language, and more than 10% of the employees speak a different language as their native language, you also have a requirement to give out pamphlets and post things in that native language. So we've got manufacturing clients, Hispanic population. We need to make sure that they have Spanish postings as well. We have clients, Vietnamese population, Vietnamese posters. Okay, so you have a couple choices, and I will tell you that there's also penalties, right, ranging from misdemeanor to fines to even imprisonment for some violations on this. I don't need to go through the 18 posters for you, but just know they come from a variety of sources, and that's what makes some of this challenging. So there are some posters that have been updated recently, which are on this screen. That's the other thing you always want to make sure of for posters and pamphlets that you have to give employees when you onboard them. You want to make sure that you're always looking to see if they're updated. Now, you can, quote unquote, order these from various places like Cal Chamber, things like that. For the pamphlets, as long as you know the list of pamphlets and you have that, then it's easy just to Google them. You can find them online. You can go to the DFEH, for example, for some of these. You can go to the DFEH and you can download them right from their site. There's no reason to pay anybody for them if you don't want to do that. Now, if you don't want to take like the time to do all that research and everything, then by all means, buy the posters from Cal Chamber. We have a service that we offer where we can provide them for you as well. Make sure that you're up to date, with all of that. Okay, so here's a list of some of the posters that were updated recently. And the other thing you want to think about is, do I want to download all of these? Do I want to post them individually? Or do I just want to go get like an inclusive poster? So Cal Chamber is pretty reasonably priced. Like if you go to Cal Chamber for their poster, you can go ahead and order that from them. There's other services out there. It's probably like $30 or something like that, just to get the federal and California state poster, one of those big ones where it comes all laminated. Just remember, you also have to post the IWC order as well. Okay, so let's start looking at documents, different types of documents. So starting with recruiting, hiring, and job placement records. There's a list of documents there. Generally speaking, you need to keep all of these records for 2 years. Okay, that includes people not hired. And this is where sometimes companies make mistakes. So they keep the applications, but once they close the position and they hire someone, they destroy all of the other applications. Cannot do that. Must keep them at least 2 years. And the reason for that's pretty straightforward. Somebody could potentially sue you for discrimination or something, having, being one of the people that applied for a job and they think that you passed them over based on age or race or gender or something like that. So the EEOC, Department of Fair Employment and Housing, say you need to keep those for 2 years. If you are an affirmative action employer and you're subject to those rules, you may have additional requirements. So you're going to want to check that out as well. Generally for employee personnel files, we're talking about things, that go in the file, the regular documents that you would keep in the employee file. These laws say 3 or 4 years, depending on whether a written agreement exists. As Marla will tell you, with offer letters, with the 2810.5 wage theft notice, all of that, pretty much everything is subject to a written contract these days. And so we would recommend 4 years beyond employment. So duration of employment plus 4 years, just to be safe that you keep everything in an employee's personnel file. If you have an affirmative action plan, it's discretionary, but we recommend 5 years on any documents relating to affirmative action plans under Title VII or the executive order that's listed there. All right, everybody knows that if you have 5 or more employees now under Senate Bill 1343 and 778, that you are required to provide harassment prevention training to your employees. That's 1 hour every 2 years and 2 hours every 2 years to your supervisors and managers. So before I mention this, just a side note, SB 778 was some cleanup legislation. Unfortunately, they did not close one loophole. That was one of the bills that gave the extension from last year. So last year we all came into the year going, oh, we have this new requirement. We have to get everybody trained by 12/31/19. Then SB 778 said, oh, you have until 12/31/2020. Everybody said, yay. Unfortunately, the loophole they did not close has to do with new hires and newly promoted people. You still have a requirement to train them within 6 months of hire or promotion. So just a side note on that, because we are seeing a problem with people going, if you're trying to figure out how to comply with that. If you need help with that, we do have different platforms that we can provide to you to catch those people. So just reach out to me or Sarai. But in terms of documentation, the other thing you need to know is that specifically if you do a webinar to do your training, or if you have some sort of online platform like we offer, there is a requirement to keep copies of the webinar, also all written materials used by the trainer, and then all written questions submitted during the webinar. So like today, as we do this webinar, as Denise said, you can type in your questions. If we were doing a harassment prevention training today, I would need to keep copies of those questions and the guidance I provided for 2 years after the training. Okay, there does not seem to be the same requirement for in-person training, but I will tell you, I would err on the side of caution there, and I would keep those documents as well. So when I go out to do live training, I provide them a copy of, they obviously they use handouts with their employees, but I provide them a copy of the training materials so they have those, and I tell them to keep a copy of that with the master sign-in sheet that shows who was in attendance. Okay, health records has a very unusual component to it. So if you notice on the lower right-hand corner of this slide, there are certain records that are required to be kept 30 years beyond employment. So this is a huge exception to our general guideline we're going to give you later. So when it comes to health records, first aid records, drug and alcohol tests, all those different things, the OSHA 300 logs, workers' comp claims, the rule is 5 years under OSHA and Cal/OSHA rules, with the one exception being that if you have any sort of toxic exposure. Like I worked at a manufacturing company early in my career, and we used a material called beryllium oxide. It affects the body similar to asbestos, in that there is a long latency period between the time that an employee is exposed to a material and the time that any sort of disease will manifest, right? So on average, like 10 to 15 years. So you can imagine if you're throwing away records at 5 years, you would never have any idea of what happened and how the employee was exposed. So because of that, they say 30 years if it has to do with chemical safety, hazards, toxic exposure records, that type of stuff. All right, in terms of benefits, anything that is covered by ERISA, there seems to be a requirement to say 6 years, but definitely not less than 1 year following plan determination. So things like COBRA notices, benefit election forms, all those different types of things having to do with your employee benefits. So talk to your broker or your carriers and figure out what type of records they keep, because they may have that requirement already, in which case you may be able to go back to them. But do you have to keep a copy of every single COBRA letter that you send out? I'm going to tell you, yes, you do. So you need to keep a copy and put it in the employee file so you can show that you actually notified them of their COBRA rights under the law. All right, FMLA records. Under Family Medical Leave Act, all of the records having to do with the leave of absence, the benefits, if you have intermittent leave, the time that was taken, all of that has to be 4 years beyond employment. You have to maintain those records. And finally, my last slide before I turn this over to Sarai, we talked to a CPA about this just to make sure we were up to date. So for income tax records under California and federal laws, the CPA that we talked to recommends 7 years. Some other changes here in terms of this, some sort of random file we put, or random slide we put together to sort of capture some things, but Social Security and Medicare records, 4 years after the taxes is due or paid, unemployment insurance records, and then if you do polygraphs, I've never had a client do this, but if you do administer a polygraph for some reason 3 years after the exam is administered is what your requirement is. And that was fast because I think everybody can read the slides, so hopefully you downloaded them. And I'm going to turn it over to Sarai right now to go start talking about some payroll records and personnel files.
Thank you, Linda. Hi, everyone. So yeah, let's talk about payroll records. So document retention is definitely one of the most important things to remember, and a very important file that should be kept are payroll records. When it comes to the law, you need to know how long to retain these files. These records should be kept for 4 years past the employee's time with the company. So make sure to add 4 years to the last day the employee worked for the company. Retaining these records for those years will actually help you avoid any type of penalties. Now remember, wage claims can go back as far as 4 years. So proper retention will help you avoid these fees. The Department of Labor can request these files. The IRS can request these files. A few examples why documentation retention is so important. What if you get audited by the IRS? What if someone claims that they were, I don't know, discriminated or discriminated when they were terminated? What if someone claims that they're not, getting the overtime paid correctly? So very important to keep these files. Aside from the documents, we know for employee information, wage records and time cards and such. Something I see often, actually something I don't see often is the notice to employee form, LC 2810.5. So as part of the onboarding process, the employer is required to provide the written notice to all the non-exempt employees. This notice provides employment-related information such as wages, company information, workers' comp information, and it's a required form for sure. That should be in those records. Let's talk about the Form W-4. This is something everyone is super excited about. They love the changes. They love the new look. I'm super thrilled about it. So we have been receiving questions left and right about this form and the new changes. So one of the main questions we're getting is, do we need all of our employees to update their W-4? And another question we're getting is, when's the deadline? When do we have to make sure these documents are updated? The answer is no. You do not have to update the W-4 for existing employees. This is only for new hires beginning January 2020. Anyone prior to that does not need to use the form. We have provided here a link where you can find more information regarding the W-4 form. There you can download the form. It'll give you reasons why they changed it, how the employee can fill it out. And it can be confusing. It's new, it's brand new. Nobody really knows how to use it yet. But if you need any help understanding us, give us a call. We can definitely talk about it. I've had clients ask me, but where do I enter the information into the payroll platform? So pretty much all payroll platforms have updated this form. But instead of entering allowances, since that's not something you can find on the new form anymore, there are a series of questions that can guide you through the process. So what happens is they will ask you if there are multiple jobs, and depending on the answer, it'll open other options and so on, so that you can actually enter this information correctly. So there's something you must know about the W-4. If your employees, and I'm talking employees hired prior to the first of the year, if your employees need to make any type of adjustments, they will have to fill out the new form. They can't use the old form anymore, so something to consider. Other files you are required to keep are the wage records. Again, same rule applies, and you should keep them 4 years past employment. So I have a story. I used to work for a construction company, and I did their payroll. Some of the jobs were certified payroll, some were union reporting and such. So we had some challenging job sites, and when it came to having all the documentation in order, it was just difficult. Unfortunately, some employees didn't understand the reason why I was hunting them down. When there were discrepancies and sometimes time cards were wrong, they were just not providing the right information. And the city was not putting up with this. The city wants accurate information. The union wants accurate information. So I remember my first assignment, the company said, "Sarai, you look like you can manage payroll, huh? Let's do a quick training. We'll get you in that position." So, I mean, I was scared to death, but I also have a hard time saying no. So Linda can tell you a little bit more about that. So that month they told me, we're getting audited and you need to go to the warehouse, pull all these reports. And yeah, so I figured, well, that's easy. What's the big deal, you know? Not really thinking about what was going to happen next. Anyways, long story short, these records were all over the place, not organized, missing information, employees not paid overtime correctly, union rules not being followed. The company ended up paying $20,000 in fines, and that was not including back pay and wages to all the employees who worked on that site for that year. So yeah, keep your wage records in order. Accuracy is important, and I think saying no once in a while is okay. So let's talk about wage statement requirements. So California wage statement requirements for employers include specific detailed information that your employees must receive regarding the wages. The employees must receive an accurate record of the hours worked, rate of pay, deductions, etc. Right? So the best place to find this is on your pay stub. Check your pay stub, make sure that the information is listed on there accurately. So pay stub mistakes that I have seen: not adding total hours worked on the pay period, not listing the start and end date for the pay period, not including employer's address, not keeping a copy of the pay stub. This is a big one. So honestly, if it weren't for a payroll platform, me as an employee, I would probably lose my pay stub all the time. I get called all the time from employees asking what their year-to-date is, how much they got paid, and some of them are actually requesting a copy of the copy they lost. So keep a copy of it. Payroll platforms have it accessible, so you can provide that at any time. Another mistake we see is listings on overtime, listing the overtime, commission, bonuses, and it might not look clear for people to understand. So make sure it's lined out clearly per item. So not listing double time, any premiums that the employees might have gotten paid, such as missed meal periods or rest periods. So another question we get asked frequently is, should we have multiple files or just one? So there are a few guidelines we should follow when it comes to filing, but honestly, my suggestion is just keep it simple. Don't overthink it. There are requirements for certain documents, such as the I-9, which cannot be added to the employee's file and should be kept in a locked and safe area that's not accessible to everyone. The first thing you should think about is, are your files secured from theft, natural disasters? Are they easily accessible? Can you navigate through them and find what you're looking for? I have gone through employee files where I have no clue where to start. Instead of everything being organized in it is just kind of thrown in there. I'll file it later. So now I have to weed through paperwork to find where their offer letter is hiding, or whatever other form I'm looking for. So I definitely recommend multiple files, but to an extent, you don't want to overdo it. You need your personnel file, and you need medical file, and especially medical files and any confidential information that might not be accessible for some people, or documents that are not entitled for certain employees. So keep those aside. Keep I-9 files in a separate binder. They don't belong in the employee's file. And we're going to talk about the I-9s a little later as well. So use file folders. That's another option. They have dividers. So that's everything, everything is stored neatly in there, organized chronologically, so you can access it easily. So don't overcomplicate it. Again, if you're a small company, if there's only one or two of you, just tailor it to your needs. So the biggest issue we find when we go to audit employee files is finding I-9s in their employee files. So it happens that when we do I-9 audits, I can't seem to find an employee's I-9. So I have to ask the employer, well, can you provide me with the employee's file? Because sure enough, that's where they end up filing it. So best practice is to choose a binder for active employees and a binder for terminated employees. Here's what I like to follow. If it is job-related documents, such as performance reviews or job descriptions, they can go in the employee file. If it is sensitive information, such as the I-9, which contains personal identity information, they should be kept separately. Again, medical records are another great example. The ADA prohibits employers from including medical information in an employee's file, so keep those separate. So I know I've mentioned the I-9s multiple times, but honestly, it's just such a huge problem. We constantly see it. So we already spoke about where to keep the I-9s, but how long are we supposed to keep these documents? I-9s are to be kept 3 years from hire date or 1 year after termination, whichever is later. I mentioned earlier, you should keep the active employees I-9 binder, as well as terminated employee I-9 binder. So keep them separate. That way you can keep track of the dates and how to store them properly. Another issue that comes up regularly, and probably as much as filing the I-9 in the employee file, is whether to attach backup or not. My suggestion, first of all, never take more than what you have used as the acceptable document. So you'll find the acceptable documents on page 3. So for example, if you use a passport, that's all you should be attaching. You don't need to list anything or have a backup, anything from list B and C. If the employee chooses to use the documents for B and C, then only have one backup for each of those sections. So not both, not one from A, one from B, and one from C, just to be sure. It doesn't work that way. I also like to be consistent, meaning if I'm going to have backup for one employee, it just needs to be for all employees. If you're not going to have any backup, just make sure it's not on, not all of them have. Sorry, I said that wrong. If you're not going to have backup for the employees, just make sure not all the files have them. You're not required to keep the backup, but if you decide so, just be consistent. So there hasn't been an update for this form, so continue using the form that expired in August 2019. So we live in a very advanced tech world, and many clients are asking if it's okay to store electronic files. If this is something you would like to do, make sure it's secure and confidential. If you choose to go with a cloud-based server, make sure that it's also separating the sensitive and confidential information. So make subfolders within those folders for clear access. There are also payroll platforms that have the option to store employee files electronically within the system. It's becoming more and more popular, so don't be shy. If this is what your company needs, absolutely go for it. It reduces storage costs, protects sensitive information, easily accessible. No one has to go to a dark storage room and weed through files. So yeah, if it's for you, if it's for your company, absolutely go for it. And if it's time to clean up your old files, make sure to shred them appropriately after assessing to see if you have kept them long enough. Linda went through some of the years that you need to keep certain files. I went through some as well, 4 years beyond employment. So make sure you're checking those dates. There are also shredding services available. Shredding can take a long time, so especially time you don't have. So these shredding services are available. They're super affordable, so go for it. Okay, so that's all for my section. I'll turn it over to Marla.
Thank you very much, Rai. A lot of information in a very succinct period of time. So my first slide, it looks like Vegas 777, overall document retention. You've heard lots of different periods of time to maintain documents. Those are what's set forth in the statute. We've consulted with tax experts, and their recommendation is for 7 years for anything that could be tied to income taxes, state or federal. So what we recommend with clients, and you certainly don't have to follow this, but we find that if you have one rule for everything, it's less likely that you'll make a mistake, is to keep everything for 7 years. The one exception to that doesn't happen for everyone, but obviously Linda's had some experience. I think maybe she's had experience with every HR issue there's ever been known to man, is the toxic exposure records. Remember to keep those for 30 years beyond employment. And then shred those I-9s as we spoke about earlier, so that you don't have those out there for anyone to review for errors, because we see errors all the time there. And I just want to remind everybody, we've done webinars on I-9 topic before, but it's just important to know. A lot of people think that the only way to get in trouble with the I-9s is if you have someone who's not authorized to work in the United States, and that's not correct. There's two ways you can get penalized with your I-9s, and that the first one is if it's just completed incorrectly, and that's where we see many errors and many penalties. My family had a business 40 years ago, which that was a case, and the penalty was $40,000. It was huge. And there was no one that was found to not be authorized to work in the United States. It was just that the paperwork was wrong. Okay, other issues. How long do you keep the documents? What about if you sell your business? Well, if you sell your business, you need to review the contract, probably with your lawyer. There's generally two types of sales: asset sale or a stock sale. With a stock sale, the buyer is buying the business and all of its records. So the obligation to maintain them goes to them. However, since we now have personal liability for some employment claims such as wage and hour, you want to make sure in that sale document that you have the right to copies of anything you need. And you might want to even put an obligation in the sale contract of how long the buyer has to maintain them so that they're available to you in case you have to defend a claim. With an asset sale, very often one of the assets included is all of the employment documents, because very often the employees are getting terminated by the seller on the date of the closing and hired by the buyer. So they want the personnel file, so they buy those as well. Again, your contractual documents in connection with a sale need to address this, because even though the buyer may be taking over the paperwork or the documents that we're talking about, they aren't necessarily taking over the liabilities. Generally, they are not. If you shut down your business, same 7-year recommendation. If there's litigation, well, this is why we have the longer periods in our recommendations that you've seen in these slides than might be found in the statutes. Many of the statutes are just 2 or 3 years, and we're recommending 7. But at a minimum 4, because the statute of limitations for a written contract is 4. So I can give you an example where I had a workers' comp claim for a company that went out of business, but the workers' comp claim was open for over 13 years. So there was documents in that personnel file that I wanted to keep forever because I didn't know what might arise out of the workers' comp claim. I don't believe there's any statute of limitations on the ability of the claimant to file for 132A action. So you never know how long it's going to be. In some cases, it's even longer than that, 7 years, unfortunately. So the next slide is access to personnel file. This is, to me, the most critical slide of all of our slides today. If you have received a request from an employee to review their personnel file or have a copy of their personnel file, or from their attorney, which is more likely, you are in the unfortunate circumstance where the attorney is now looking for something wrong. The request for the personnel file usually also comes with a request for payroll records, and this is where it gets tricky. The request for the personnel file is under Labor Code 1198.5, and under the wage statements, it's under Labor Code 226 sub B. And the reason why it's tricky is because there are different periods of time. The attorneys will very often send the request in the same letter, but you have to provide the personnel files within 30 days of a receipt, not within 30 days of the letter, but 30 days of when you've received it. So you need to make sure that somebody is documenting when it was received. And with the wage statements, the payroll records, it's within 21 days. And that request can be verbal, doesn't have to be written. So there can be an argument immediately. Who said what to who? And so you want to document if that verbal request has been made, when it was made, confirm it in writing to that person. Those of you who have been in the HR field for some time might remember in the old days, you only gave copies of things that were signed by the employee. Well, that's not the case anymore. They're entitled to copies of everything in their file, nearly everything. I'll go through a couple of very minor exceptions. They have the right to ask to inspect at the office or have copies sent to them. You, as the employer, this is the only place where there's some help for you, is you can mail. The code actually allows you to mail it so that they don't come into the office. I think it's very uncomfortable to have a lawyer or personal representative of an employee come in and inspect records. So we always recommend that they get mailed. We also always recommend that before you mail them, that you send them to us or to your HR consultant like Linda or your other counsel so that the file can be reviewed. It's very often that it's for an employee that's been terminated, and in discussions with the client, I say, well, there's nothing in here about performance, there's no warnings, and in discussing with the client, we determined there were lots of warnings. There were lots of oral warnings, but nobody documented them. And there's nothing wrong with documenting them now. You can't backdate them, but you can estimate the date that you gave the oral warning or not give a date at all. And if you were ever called to testify, you just must be honest about when you created the document that went in the personnel file. But the purpose for that is we want to make sure that everything we can put into that file that would dissuade the attorney from taking a case against an employee who's claiming they were terminated for a wrong reason, we can show the right reason so that the employer might not take the case, or excuse me, the lawyer might not take the case. And that does happen. The penalties for failing to comply with either of these statutes is $750, but plus injunctive relief and attorney's fees and costs, which can amount to a lot more than the $750 because the attorney's fees alone are very expensive. So I just want to touch a little bit, since it's in this area, on the wage statement. So I went through what needs to be in the wage statement. And there's two ways that the employer, again, just like the I-9, can be penalized for that failure to put in the wage statements. The first is the failure to provide the wage statement under this request, and the second is errors in the wage statement. And the penalties there are huge. It's the greater of the actual damages, or $500 for the initial pay period and $100 per pay period after that, not to exceed $4,000. But again, it's plus costs and attorney's fees, and often the attorney's fees are greater than all the numbers I'm giving you. So this is an area, again, I think is a trap for the unwary. You've got to look at the 30 days and the 21 days and don't think, oh, well, I'll just comply with the 30. You've got to comply with the 21 on the wage statement. So I like to have one rule. So if you get a request for both, let's just do them both within the 21 days. And again, my recommendation is that you have counsel review it. What you don't have to provide, we often provide it anyways, but the statute says you don't have to provide records related to criminal offenses. You don't have to provide letters of reference, and you don't have to provide ratings, reports, or records that were obtained prior to employment or obtained in connection with a promotional exam. Now, since these areas can cross over into other areas of what you do have to provide, unless there's a specific reason not to provide them, we recommend providing them. You also may, and most employers forget to do this, but you may redact the name of any non-supervisor employee who might be contained in the personnel file. So if you have an investigative report, for example, and there's other employees in there who aren't supervisors, you may want to redact their names. We do that very rarely because we do, again, want the attorney who's looking at this to look at all the facts and make a decision that, oh, there's too many facts here to support the claim of the employee. The employer looks like they did a good job of documenting why, the correct reason and the legal reason why they terminated the employee. So practical implications. Consider creating a request form for inspection or copy of personnel records. Just note that they don't have to use the request form that you prepare, but they may, and it may help you with those dates and especially getting away from the oral requests that we talked about earlier. Consider designating an individual to whom requests should be made and put in place processes to ensure compliance. This would be in your handbook. You'd be advising the employees if you do want to request this, request that you make that request to HR or to the CFO or whoever is handling HR issues. Again, they do not have to do that. The code doesn't say your request has to go to that person, but if you put it out there, a lot of times they will voluntarily comply. And train your HR employees regarding access requirements and update all relevant policies, procedures, and handbooks. This goes to items 1 and 2 as well. Once you decide what the policy is, train people to follow the policy. Unfortunately, that doesn't always happen. And then ensure you can reproduce the wage statements and the personnel file. This goes to the earlier slides of keeping things electronically. you want to be able, you can transfer them electronically as well, provide them to the other side electronically. We often ask as a courtesy if they prefer that. But you need to make sure that whatever you have can be reproduced. And always track the dates on which those requests are made and the timely responses. Track the number of requests because there is a limit on the wage statements to 50 per year. And then again, track how long you've got the records and you're going to maintain them. The next slide, problems with documentation. Lack of documentation, probably the number one problem. As I said earlier, getting the personnel files that's been requested from the employer sent to us and finding out there's a lot of information that should have been put in there with respect to this employee and wasn't. Again, that's why we want to look at it before it goes to someone else. We can go ahead and put that in. I get a lot of manufacturing supervisors who are on a line, if you will, a manufacturing line, saying, I don't have time to shoot an email to HR and say, I talked to Joe about not having on his steel-toed shoes. I said, but you do have time to write it down on your blotter on your desk. If you have a calendar blotter on your desk, which a lot of them do, or any other, record. Some keep a calendar in a book or just a book of pages that they keep things going with respect to moving the product line along. So write it there. And then at the end of the month, tear it out and send it to HR and they can throw it in files. Even if you don't do that, if you've written it down somewhere, when I come and I ask, why did you terminate this employee? You say, I told Joe every Friday, you're missing your steel-toed shoes. You're missing your steel-toed shoes. You're going to get fired because this is, an OSHA problem for us. And you have it written down anywhere. We can tear it out then and include it. So that lack of documentation is your best defense against legal claims to show any kind of employment action taken, whether it's termination or otherwise, was proper. Separate supervisor files, that's kind of the opposite. Then you've got the supervisor who's keeping all these files, but they're keeping them separate to themselves and they're never sharing them with HR. And we don't ever know about them until the deposition of that supervisor. Someone asks them questions, oh yeah, I've got a whole file on Joe. So you want to make sure that they know that's not appropriate. Investigations, you want to make sure they're properly done. My recommendation is that you always use counsel to get an investigation done, even if it's going to be done internally. There's nothing wrong with internal investigations so long as the individuals conducting the investigations are not involved in the investigation. They're independent, and they're not investigating their supervisors who might terminate their employment. Performance appraisals, we've done webinars on this. This is one of the hardest things even for me. I don't like to give performance appraisals. So we give webinars on how to do them, and boy, it's an area that changes all the time. But if you have them, and you should have them in some regard, depending on how you do them, it doesn't have to be the old-fashioned way where everybody gets a 5 or a 4 or a 3, but just a discussion. Your employees should always know where they are and how they're doing. If you have an employee that you've terminated, that's surprised the supervisor did not do their job. So that obviously wants to get into the personnel file. Email. I want to review emails and also performance appraisals, for discriminatory languages or references to protected classes. Social media, same thing as, you need to look at it if you can. Again, you can't ask for any passwords. Social media and email, just remember, we advise employees this all the time. You can delete all you want, as long as I pay an expert enough money, I can find it. It never truly goes away. I want to go back on investigations for just a minute and tell you a quick story of a company that Linda and I both worked for, although I think she was gone at the time this happened. We did the employment work for a firm that had an internal investigation, and a very high managerial supervisor write an email to the president of the company and say, we should pay this gal some money because we discriminated against her. Those are all legal terms and legal conclusions that only a judge or a jury or an administrative body like the labor commissioner can make. That's not a determination that a manager can make. They can say, I think we did something wrong here. I don't know that we should have done this. I really don't want that in an email either. Because what happens with that document, if that matter goes to trial, is it's a giant poster shown in front of the jury. And the jury is told, look, even their own employee, their own supervisory employee says they discriminated against this individual. So we've got to be very careful. We've got to train our supervisors what they can and can't put in writing with respect to investigations if they're being done internally and not outside by a professional who's trained to write the conclusions on those investigations. And then next slide, this is just an example, a timing example, because you've heard us talk about, oh, this is 2 years, this is 3 years, minimum 4 years after employment. We're recommending 7 because of taxes. This is Sue having a written employment agreement, and her employment ends on January 23rd, 2020. So today. Thank you for that, Linda. Then Sue, now because of the new change under the law, has until 2023 to file a complaint under FEHA for discrimination, harassment, or retaliation. Brand new law, long period of time for those of you who try to retain facts. 3 years is a long time. Sue's attorney has until 2024 to sue after receiving a right to sue letter. So 3 years to file the complaint, and then as soon as the DFAH says, here's your right to sue letter, sometimes it's immediately, sometimes it's a month or two after, then they have Sue's attorney has 1 year after that. Then once the lawsuit's been filed, it might sit on the attorney's desk for a while because he or she has other things to do. It doesn't get out to serve the employer. Service means handing it to you and giving you notice of it that it's out there. So it could be another 60 days after that. The point here is memories go, and documentation, which could support the employer's position, could be lost. And that's why we don't want it to be, and we want you to use the information we provided today to maintain that document for your benefit. And with that, I will turn it over to questions and answers. I think I've finished right on time.
You did great, Marla.
Hello?
Yeah, I'm like,
I thought I lost the entire group.
You did great. I told Denise, and maybe that's why she paused, because I told Denise, like, I want to ask you a question and get your opinion on something before we turn it over to Denise. Denise would like to tell everybody, though, make sure that on the dashboard over there that you have on your system, there is a place where you can type in questions. And she's going through those right now, and then she'll be asking us those questions. But Marla, I was thinking about something when you were talking about files and redacting names off of records. What do you usually advise your clients when it comes to training records? Because from a practical standpoint, you know, someone walks in a room to do harassment prevention training, we've got a sheet of paper there, everybody's signing on the same sheet. Are you okay with them copying that for every single employee file? Do they need to redact everybody else's name on that list except for that, you know, for the file from the employee that they're putting it? That's not proper grammar, but you know what I'm asking you? Like,
I know exactly what you're asking me, and I think it's absolutely okay to copy copy it and just put it in everybody's file without redacting anything. And here's why. You look around the room, you see who's there. It's not confidential. It's not a confidential, it's not something that an employee would have a reasonable expectation of it being private. You might even have the UPS guy walk in and, you know, you're all in a bubble of a glass room and see people in there. So it's not something where anyone should expect that it's private. So yes, I'm absolutely okay with just making a copy of the sheet of attendees and putting it in everybody's personnel file.
Great. So let me ask you a follow-up question to that. I'll play counterpoint just because I've had an experience with this before. So this is why I'm asking the question is, then somebody requests a copy of their employment file, right? And let's say they plan to bring some sort of wage and hour claim or something like that. They get a copy of their payroll record and their employment file, and lo and behold, now their attorney has the list of all of these other names that potentially now become a class action.
Yeah, the litigators would tell you absolutely to redact it at that point because they don't want that. But the reality of it is, and again, I'm not a litigator, but the reality of it is the employee who has gone to that attorney can say, you know, here's Mary Beth's phone number and email address and LinkedIn address and Facebook address. Here's Joe Smith's LinkedIn address. And they know who they work with. So I have less of an issue with it, a litigator. So you need to talk with your own counsel. And unfortunately, the way of the law is there's very rarely a black and white answer. It's a risk assessment and what you want to do.
Thank you. All right, Denise, you're up.
Okay, thank you. As Linda mentioned, you can type your questions in, and there were a lot of questions in the Q&A section today. So we're going to do our best to answer your questions, and just know that if we do not get to answer your question today on the webinar, we will reach back out to you to answer the question. So the first question we have is going to be for Marla. Marla, Chris wrote in this morning and asked, does the law allow us to use electronic signatures on documents, or do we need wet signatures?
So the law does allow you to use electronic signatures. For those of you who are code geeks, it's the Civil Code 1633.7. There are a lot of exceptions to that, though not in the employment world so much. So for those of you who are interested, those exceptions can be found in Civil Code 1633.3. For example, if you're buying a car right now and you're financing that car, that auto paper that you've all seen, you can't do that on an electronic signature yet. It's coming. I think electronic signatures are coming for everything. The issue that you will read about, if you look at the code section on the exceptions, is you got to be able to prove that it's a signature. So this case law, for example, where someone said, is this okay with you, in an email, and the email came back, yes, I agree. That's not a signature. That might be an oral contract depending on what was being discussed, but that's not a signature on something. So you need to be very careful that you are using electronic means that you can show it is a signature. And those of you who have signed loan documents with signatures or done anything with a large CPA firm, they do quite a bit with electronic signatures, and they have to comply with a lot of privacy laws. When you're actually signing, you have to go through a couple steps to get that electronic signature signed.
Okay, great. Thanks. We have a couple questions on W-4s and on payroll. So Sarai, we're looking at changing payroll platforms in the next month, and you talked about how long to keep documents. What do we do to hold on to the payroll records after we change to the new platform?
That's a great question, Denise. Well, definitely, if you're going to be changing platforms, you can be proactive and download the appropriate documents regarding payroll. That's going to be your payroll register, pay stubs, anything that has to do with wages and your employee. Definitely download those. Now that we know how many years you need to go back, definitely try to get as much documentation as possible. Save those in a secure, safe location in case you ever need to go back to them. I know that payroll platforms have, for example, Paycom specifically, they have a checklist. So if you talk to your representative, they have a little checklist where you can kind of go through each file that you should have records of, and that way you make sure to have everything within that year and go back as far as you need to.
Great, thanks. We had a couple questions on W-4s, and as Marla was mentioned, things are going electronically, so there's a few questions about employees and W-4s. A couple of questions on this particular thing is regarding W-4s. The companies are using a cloud-based payroll software, and their employees have the option to update their W-4 online in the self-service app. Are they also required to submit a W-4 paper form afterwards, as most companies are going paperless?
No, you don't have to submit a physical document. A lot of the payroll platforms are all doing the W-4s electronically. They've already switched over to the new payroll, the new W-4 format that started now in January, and you can fill it out there.
Okay, great. We had a question, and I think Linda, you might be able to answer this one about I-9s, or maybe Sarai actually. What about I-9s that are electronically input? You talked a bit about keeping the I-9 form and how you should do the files. Should there always be a paper copy of an I-9 form?
Okay, so yeah, let's talk about this one because this has some tricky rules around it. So you can fill out an I-9 form different ways, right? So they do have a version of the form. We all know you can print one out and everybody handwrites in their information and messes it up and then turns it into their employer, who compounds the problem, and then they get fined. That's like my model for how I-9s work. But let's just say everybody does it correctly. You fill it all out. You can just keep that document, hard copy document with a wet signature in the I-9 notebook as Sarai described. They also have the version that you can fill out online. The good part about that is that it's sort of dummy proof, right? It does not let you put in a date using the wrong nomenclature. Like you have to put in 2 digits, 4 digits for, month, day, and year, things like that. It doesn't let you put the wrong document in the wrong, column. So that's the good news. You cannot sign that document electronically, okay? You have to print it out, sign it with the wet signature. However, once you do that, you can upload it and save it electronically and destroy the original I-9 form. So you do not have to keep the hard copy of the I-9 form. So you can do it that way. There is a third option. Some payroll systems, as an example, have worked around the very specific requirements to allow you to sign the I-9 form electronically on their platform. I don't know those off the top of my head because honestly, when I looked at it, I was like, oh yeah, we're not going to do that. I don't know if Sarai remembers what they are, but it's a multi-step process. You have to be able to verify, like different ways and to make sure that it's the person that's signing it, all sorts of different things. Like Sarai, do you remember what the requirements were? Can you speak to that at all? If not, people look it
Off
up.
the top of my head, no, but I remember for one of our clients, they had employees that worked out of state, different states, and they didn't have a way to fill out their I-9, obviously get the wet signature because this employee was in a different state. And I know that one of the options is going through a
Notary.
notary, right?
Yeah.
That is qualified to do I-9s as well, because I guess there's, 2 different options.
Yeah.
Or you have to
Because
have that option as well, but not necessarily,
yeah,
I don't
because
know off the top of my head.
that's the issue also, right? You still have to inspect the original documents. So that's the other thing to keep in mind. So even if somebody's going to go into a payroll platform and fill it out or whatever, for the employer side to certify it, you still have to inspect the original documents. So I don't know how much effort is saved, but if you do have a hard copy document, I-9 form that's been saved, once you upload it and save it, you are allowed to destroy the original with the wet signature.
Okay, before we pivot to a different topic, what if someone thinks the I-9 is wrong? Can they ask the employee to fill it out again?
No, but there are specific ways to make that correction. So that's something you should just reach out because we don't have time to go through how to correct it. We do have a webinar on that. If you go out to youtube.com/ethoshcs, you can look for an I-9 webinar. And we did discuss how to make corrections, but there are very specific rules about how to correct an I-9 form. Once that I-9 form has been completed, there are a couple of reasons you might have them fill out a new form. But there's other, depends on what the issue is when you say not filled out correctly. There's a lot of reasons something is not filled out correctly.
Okay.
Time for one more question?
I think we have time for one more, and then whatever questions we didn't get to, because there's some multi-part, we'll make sure that we follow up. In the beginning of the webinar, you talked about video platforms and training, Linda, and you talked about how you do handouts. What if we provide a video platform training and there are not training materials available for the people who attended the training session to keep?
Yeah, I would be very careful about that. I would reach out to whoever is providing the platform and make sure that you're able to get a copy of their training materials. Because the way I read that rule anyway, unless Marla feels differently, the way I read that rule is that that is a requirement that you have to be able to produce those materials. So, we also have the rule that the training has to be interactive. So there's other things that have to happen. That's why, I know that there's a lot of people, companies online that provide, on-demand training like that. I don't know how they are complying with all of those rules. I know that the training that we develop complies with those rules, but I am a little bit concerned about some of the other platforms that I've seen because I don't see how they're making it interactive. We have quizzes built into ours. We provide them with our telephone number and our email addresses so they can reach out if they have questions, things like that for our on-demand platform. If you're doing the webinar live, then that's an easy one, right? And in the case like when we do a webinar live for our clients or a public one, we're maintaining those records for you, so you'd always be able to reach back out if anybody ever questioned it.
Okay, great.
All right, it's time to wrap up. So I'm going to talk about next month. So first of all, thank you all for your attendance today. If you have any questions, reach out to one of us. You see all 3 of our email addresses on the screen there. I am very excited about our webinar next month. Those of you that have been around for a while might remember Linda Zimmer. She's spoken to us before. She is a marketing person. In fact, she and Denise tag team on doing like our website and things like that. I think Linda's brilliant. She can speak on a lot of different things. She is a certified privacy manager. They have this California Consumer Privacy Act, and it has gotten more robust, the laws around privacy have. And so some of the HR related ones with regard to employee information doesn't go into effect until next year. Some things you need to be aware of now. So Linda's going to talk to all of us from an employee rights and employer responsibility standpoint, what we need to know about that Consumer Privacy Act and what we should be doing now to prepare for that. So she will be here on February 20th. The link to register is right there. So I hope you will come back and join us when she is here next month.
Thank you, everybody.
Great. And with that, that concludes our webinar for today. We appreciate you participating, and we'll follow up on the questions that we did not get a chance to follow up on. Thanks, and have a great day.